The petition number 1 is appearing higher secondary examination, which is commencing today.
What can be done? Where you were last day, one matter was there. We have already
Actually,
passed an order.
Actually, that matter was not called, my lord, due to my sudden fever.
But somebody, your junior mentioned the matter. In one of the matter, we have permitted him to sit in the examination.
No.
Yes, you were there. You were there. We permitted him. Have you taken all the steps?
Actually, my lord, this is the agreed.
We can't. Where you were? Yes, on Tuesday, where you were? But somebody now today kindly now examination has started.
He already appeared in the examination on my accident.
So let him appear.
No, not for the rest.
4:30.
4:30.
There is no hurry. 4:30.
There is nothing.
Lord, I beg
Don't
your
worry.
lordship's leave.
He is appearing. Let him appear.
Lord,
No, that's true.
I beg your lordship's leave to mention a matter, my lord.
What?
But I'm seeking to file a WP-LRT against an order of the LRTT, my lord. But the difficulty that I'm facing is that, my lord, I have a plain copy of the impugned order.
When the order was passed?
My lord, 10th of January 2024, but it was communicated to us in the month of February.
No. My principle is once the limitation has intervened, we don't permit without certified copy.
My lord, we had received this. We have
No.
received the copy of the order.
No.
Lordship,
If the limitation has intervened, no.
My lord,
30 days has gone.
certainly.
Lordship, Mr. Advocate Shivashish Ghosh is appearing virtually, Lordship, for the leave, praying for the leave.
Let the matter be called.
My lord, Lordship, mentioning Lordship.
Mentioning nothing.
My lord,
Give.
my lord, there's some urgency, my lord, if your lordship permits us, my lord.
What?
My lord, the civil matter, my lord, it's item number 377 in your lordship's list today.
No,
my lord.
we'll take up the civil matter. We have already instructed one day
My
with
lord,
the precedence to all civil matter.
my lord.
I think if everybody agrees, we can do it on a Monday or a Tuesday or a Wednesday or Thursday, any day.
My lord, will it be my lord's convenience to keep it on Wednesday? If
Wednesday, civil matter first, we don't mind. Thursday, it has been indicated. He wanted a Tuesday, Wednesday. I don't have any
very
issues
well,
on
Thursday,
this.
my lord, I don't have a problem. Thursday is fine with me, my lord. There's no problem.
Thursday, all civil matters first
Very well. my lord.
and no adjournment. Hey, liste, আজকের liste ওটা indicate করে দাও that civil matters will be taken up on Thursday.
The problem with Thursday is, my lord, if it's a hearing matter, if it spills over, then my lord, that will be a little bit of a difficulty. That's why I
Then
was
Tuesday, Wednesday you want? I don't. Tuesday I can do it. No
Wednesday-
difficulty.
Wednesday, my lord, if it comments to
I don't mind.
my lord.
Tuesday or Wednesday.
Wednesday.
It spills over then.
To Thursday, my lord, then still we have time, my lord, to because it's a civil matter, it might take a little bit of time.
Nothing. Will
Nothing.
not take time.
Will not take. I'm sure, my lord.
Will not.
Lordship, may I permit
On
mention for the
Wednesday করে দাও.
Grateful.
Come on,
dear.
Wednesday, do it.
So
My lord,
grateful.
I'm praying for leave to mention a matter, my lord. For restoration, my lord.
Lordship, praying for the leave to file one mandamus appeal without Lordship certified copy, Lordship.
When the order was passed.
Lordship, at 13, Lordship. Lordship,
13th
at
of what?
13th of February, Lordship. Lordship, at that
Just
time.
now.
Lordship, just now, Lordship.
Have you applied for certified copy?
Lordship, at 13.
Have you annexed the photocopy of the application?
Lordship.
Have you annexed the photocopy of the application for certified copy?
Lordship. Lordship, also, Lordship, praying for the urgency to take the.
Whatever, let us see.
Lordship, let the matter be listed on 19, Lordship.
My lord, just to
90.
inform your lordship, lord.
It
Lordship,
will appear. First you go and file
Lordship,
it.
it's a tender matter, Lordship.
Please go and file it in the department first.
Lordship,
Go. We are granting your leave. It will appear.
My lord, just to inform your lordship, the Calcutta bench, my lord, is probably not sitting today because there's a 10:30 demise of Mr. Idris Ali. There is a resolution of the bar. I'm sure it will be communicated. my lord.
Then everybody is mentioning, if they mention the matter, they have to do the matter.
Yes.
Yes, do it.
Lordship may be permitted to mention a matter.
Yes.
Lordship is my anticipated date is running in the list at 158. Lordship, the other co-accused persons, several co-accused persons are.
Whatever we will take up, don't worry about it. Don't.
Examination matter, all that is different. I personally visited, they are attending the examination.
Thank you. That we need your appearance for that purpose only.
My lord,
Yes.
may I be permitted to mention a matter, my lord, if your lordship kindly allows me, my lord.
What?
My lord, I'm mentioning a matter, my lord, a tender matter, my lord, if your lordship kindly sees, my lord, I seek your lordship's leave to file an appeal without the certified copy, my lord. My learned judge has just now mentioned this matter, my lord. 24th, 19th is the date for opening the tender bid, my lord. And there was no
No,
allegation.
let them file it. They have filed it. Let them. It will appear on Monday.
Kindly direct it will be listed on the priority basis. my
It
lord.
will be there. It will be there. First you go file it in the department.
I can address your lordship on that date, my lord, if your lordship
No,
kindly.
no, you file it. It will appear. Don't worry. We'll take up.
Kindly take it up in the top of the top, my lord, the list, my lord, if your lordship kindly fixes the matter, your lordship kindly fixes it.
What for what?
For the
Sorry. We don't upgrade the matter. Yes.
Lordship, may I be permitted to mention a matter, Your Lordship? Item number 26 running in today's list, Your Lordship.
Yes.
It is a mandamus appeal, Your Lordship. Kindly.
26. 126.
266, Your Lordship. I
We
apologize.
will take up on Tuesday. We'll take up the mandamus matter first. Don't worry. Do it.
Your Lordship, it's running in the list since 2 circuits, Your Lordship.
Madam, we are here, sir. Madam, Monday, none of your member of the bar appeared.
Yes, Your
The
Lordship.
Tuesday, only the bail matters we could dispose of.
Yes, Your Lordship.
Wednesday, Thursday is a holiday. Now, Friday we are taking up. Let us start. Today also, somebody said, I do not know what would be the reaction of the bar.
Deeply
If you
obliged.
can do it on Saturday and Sunday, I am ready to work. Are you ready? No difficulty on my part.
Your Lordship,
If
as
all of you agree, I can sit on Saturday and Sunday as well. I sat in the principal seat, no difficulty. If everybody agrees, I am ready.
Lordship, as per the convenience of the court, Your Lordship.
Yes.
Deeply obliged, Your Lordship.
Yes, call that. ওখানে একটা বড় ম্যাটার ছিল হিয়ারিং এ অন্তত 50টা কাউন্সিল and it was a HARISH matter. So I said that every time when a matter is taken, we engage in another. I said, okay, we on I will sit on Saturday. There will not be any problem. Seamlessly, everybody come on. Ultimately, pending in the situation. Sorry. Yes, who is appearing for the petitioner? Nobody appeared on the last occasion also. What? What does it mean? What does it mean? If you attend the court, then you do the court. Do the matter. I mean, if you attend the court, do the matter. Not today. Paul,
Lord, in item 2, I appear for the petition. Lord, this matter was heard at length on the last day, and my lord, after that, Mr. Jagriti Mishra had intervened in this matter to.
where is he?
যদি parties ready থাকে তাহলে।
So what? Yes.
Matter, my lordship, there was
You just flagged an issue on the last occasion that once the accused who have been apprehended is produced before the magistrate or the court, then whether there is any inconsistency or lapses at the time of an arrest, that gets effaced for the time being, and nobody can take advantage of that particular lapses. This is what you said, that we just put a halt at that stage. Because what I find is, I tell you very frankly, what played in our mind was that so far as an arrest is a first step taken by an investigating officer for the purpose of arresting a person and really acting opposed to the fundamental rights enshrined under Article 21 of the Constitution, because that is not an inchoate or absolute or a sacrosanct right, but is always subject to the established procedure of law. And this being an established procedure of law, now the question is, what is established procedure of law? If the law mandates a particular act or the thing to be done in a particular manner, if it is not done, then whether subsequent act of the officer who is an erring officer who has not complied the mandate of the act, produces the accused before the magistrate, whether those act takes a backseat and will be completely effaced and the court will not look into those aspects. I believe that really, I personally have a lot of reservations in this regard. Because the foundation, if it goes, then it will crumble down the castle which is built upon it. So that is what was my view. You have said, obviously, the law has to be respected. So that's why we take a backseat of it and wanted to know.
My Lordship, the issue, there are three things.
So that's why I expressed my mind. That is what is playing in my mind.
I understand where my Lordship is coming from. It's like if the foundation is bad, then if there is an illegality in the womb, then it goes up to the tomb. That's what the law is. Lords, what happened here is, my Lords, there are three different things that needs to be looked into. The first, my Lords, is the incident. The second is the issue, and then the broader issue. The incident, my Lords, is what I could gather from the memo.
Forget about it. Incident is whatever he has been apprehended, having possessed the.
There was,
you know,
under column 10, my Lord, there was
Yes.
signature of the accused himself.
Correct.
That, my Lords, is the incident.
Correct.
Now, if my Lords have a close look at the memo.
No, that is not an incident. That is really a follow-up action which is required to be
No,
done.
in
Incident is that he has been caught. He has been caught. He has been, I would say, he was obstructed by the officer. And the second incident is the seizure. And the third one is the formalities which is required after search and seizure, and then while arresting or apprehending a person. So this is what is a third step in my view. Please correct me if I am wrong. So that can't be an incident. That's a follow-up action.
If my Lord have a look at the memo of arrest, there are 11 different columns that is there in the memo of arrest. Column 10, my Lords, is the
Witness, local witness, or any person who is a member of the family.
column 10, in fact, my lords, is followed by column 11,
Hmm,
which is meant for the signature of the accused.
correct.
So what probably would have happened in this case, and I'm talking only about the incident, what could have probably, because the gap therein
Now,
between
then,
column 10 and
I
column 11
understand.
is
I understand. Where you are heading, I understand. You said that there may be a mistake on the part of an accused while
Accused
putting a
himself said-
signature.
My lordship.
While putting a signature, instead in front of the column 11, he has put
in
it.
front of
Then
column 10.
one has to understand that the column 10 remains blank.
Blank.
Blank. Blank.
If it is a blank, if it is not, then what is the
If it is a
what
blank,
is a what is a what is a
the
fallout
natural
of
consequence thereof is not bail.
fallout? No, the problem is because if the DK Basu judgment is to be considered, 41B is to be construed in this manner because the DK Basu says 41B has to be construed as mandatory provisions. It never says it's a directory in nature because this judgment led 41B to be brought in the statute. I'm just giving an example of, this is a very academic discussion, like a Visakha guideline. If you look at the Visakha guideline, there was no legislation in place.
My lordship.
There was no difficulty on the part of the Supreme Court to lay down a particular procedure or a legislation which is not there, enacted by the legislators, to be applied, to be tested, to be gone into. If the legislation has come, then the legislation has to be read conjointly with the mandate of the Visakha guidelines. If something new has come, something new provisions has come, that does not mean that the Visakha guideline has been completely sidetracked. If the very foundation of the legislation is that particular judgment of the Supreme Court. Here also the identical situation arose because there was nothing coming out in the codicil procedure. The DK Basu, the Supreme Court has said, no, at the time of an arrest, you'll have to follow these
There are even
mandates.
guidelines that needs to be.
Guidelines. On the basis of those guidelines, 41B came into effect. And it is not inconsistent with the judgment of the DK Basu. It is in tune with the judgment of the DK Basu. There are many legislation. When we go in a civil side, then arbitration and conciliation. The Supreme Court in Ashoka Builders or Associate Builders or Ashoka Builders, I do not know. Associate Builders have already, Justice Nariman has said that this is what is required. You can't get away with this. That led certain amendments to be brought in the arbitration and conciliation. Now, the moment the amendment has been brought, the statute has come. If the statute does not run counter to the mandate of that particular judgment, then at least the guideline which has been issued, the formation, the main substratum has to be understood in this way. And then the court will say that whether it is mandatory or it is not mandatory. What you say is a very innovative, that's really stuck my mind as still a student of the criminal branch of law, as an student. It struck me that why? And I do not find a very strong reasons for that. I tell you very frankly, because what I perceived is that if certain things are required, which is a base, if that is faulty one, whether this gets remedied or redressed by a subsequent act is a very larger issue to be gone into. How you interpret it.
If I can have my lordship for a moment on DK Basu itself to begin with. In DK Basu, we need to understand DK Basu in the perspective that it was given. DK Basu is a judgment that deals with custodial violence and custodial torture. Now, the consequence of not following the 11 guidelines in DK Basu has been given in DK Basu itself. If I can have my lordship for a moment on paragraph 30. Paragraph 3030, my lords, of the judgment. There are 11 guidelines that has been given.
No difficulties.
These guidelines, broadly, we all know what these guidelines are. After the 11 guidelines have been given, what would be the consequence of not following the 11 guidelines?
It says the failure to comply. It is failure to comply with the requirement shall, apart from rendering the concerned liable for department action, also render him liable to be punished for contempt, and the proceeding for contempt of the court may be instituted having territorial jurisdiction.
There is no other consequence that.
In the
I think, Mr. Mishra, there appears to be some kind of confusion in your mind. Many statutes you will find contained a penal provisions that in the event if there is any violation or non-adherence of these provisions, that the penalty is also provided. And you visualize penalty both in a monetary terms and sometimes the criminality is also attached to it, that he can also be punished for a period of such and such. The question then arose whether if there is a penalty provided, whether this provision has to be considered as a mandatory provisions or a directory in nature. And you visualize. What he says is other round thinking. Why the learned judges in the Supreme Court incorporated this particular paragraph. Paragraph is, the object is that if you do not comply, then you will be liable not only to undergo disciplinary proceedings,
But also
which is a very harsh one, but also may be rendered liable for punishment under the Contempt of Courts Act. That what does it mean that? That if an officer can be booked for non-compliance of those guidelines or those instructions, then is it a law that it will not inure to the benefit of the accused? It will not.
DK Basu talks about condemnation. It does not talks about condonation of whatever charges that has been leveled against the accused.
Now the question is what? If there is anything which is lapsing, or there is a lapses in this, how can you? Because the DK Basu says that these are the guidelines, these are the things which have to be followed mandatorily. If it is not followed, then
That's
what is
illegal.
then what is? Then it's illegal. If it is an illegal, then illegality for one and the legality for another. I am asking whether illegality will be segregated into two compartments. It will be illegality for one. Illegality is, again I am saying, then distinction between a void and voidable. One may treat it as a void, but one may, as a voidable, may not treat it as a void. Here, illegality does not come under any kind of a compartment. Illegality for all time and for all purposes, it is an illegal one.
If that be so, my lords,
It
then
can't be legal for one and illegal for another. No.
as a devil's advocate in that case, my lords, let's concentrate on point number 11.
Why not ghost?
No. Let's concentrate for a moment on point number 11.
Yes.
Point 11 of the guidelines says that there should be a police control room that should be established in every state. Now, for example, if there is no police control room that is established, then all the arrests are illegal in that state.
No.
But the
That
natural
is,
consequences.
I'm saying there lies a fallacy in your submissions. Every statute has both the substantive part and a procedural aspect as well. If the mandate is given that in every police station, there should be a particular dedicated zone for this. Take an example of a Juvenile Justice Act. Now, there is a mandate which has come that every police station must have a child-friendly corner where the juvenile or a child who has been taken cannot be taken in a regular police station. He will be taken in a child-friendly corner, which is more congenial and conducive for those children, and not inculcating a sense of a regular retributive service, justices, opposed to a retributive system of justice. This is what is the object. Suppose if the child-friendly corner is not there, all the act done by the juvenile gets eroded? No, because this is what is the procedure, which is what is the mandate, which is foisted upon an authority to do that it should be done in this fashion. But a substantive right has to be understood in this. If the substantive right is that if there is no non-adherence, then what would be the outcome or the consequences thereof? Question is whether it falls or it does not fall. If the mandate is very clear that you will have to do this, blah, if it is done. I'm giving you a simple, like another example, as a good lawyer. This is all academic.
No, I bow down to that.
As a counsel. Under the NDPS Act, there is no provision for a second testing. Is there any provision? No, there is no provision. You will find provisions in drugs and cosmetics Act. You will find provisions under the Central Excise Customs, where the authorities can send it for a second time testing. But you will not find a single provision under the NDPS Act, nor any provision under the Code of Criminal Procedure. No, zero. Then what? If this is a gray area, then what do you expect that the court should do? The court can fill up the gap if there is by using its power under Article 227 also, by using its power under 226 also. That can be done. There is no difficulty. If I am not wrong, I think the Thane Singh or a Tufan Singh judgment is
Tufan Singh.
Yes.
Which one? Tufan Singh.
Thane Singh. Not Tufan. Tufan Singh is the different. Thane Singh. Paragraph 23, if I correctly remember, if my memory goes right. The Supreme Court has said that why not? If there is any discrepancy, if the investigating officer found that I'm not happy with the FSL report submitted by
The CFSL.
CSFL or SFSL? We don't. Forensic laboratory or laboratory, we're not. Why not? He can pray for a second test. Supreme Court later guidance that the moment you receive the first report, within 15 days, you have to apply with the reasons to be given for second test. Then it says that the court or the concerned judicial officer, while dealing with this application, must satisfy its conscience and record the reasons that why he is permitting the second test to be done. There is no observation in the Supreme Court judgment that if it is not done, then what would happen? Consequences of that. This is only a conferment of right without any consequences. Then the question often arose, suppose if it is not done, means within 15 days not filed. Yet the magistrate mechanically allows the second test, how far it will go. Second, filed within 15 days without recording any reasons that why second test is required. What and the magistrate in a mechanical manner allows. What is the outcome of this or fallout of this? Thirdly, there is a reason which is provided in the application, but the magistrate did not record his reasons, any reasons, and mechanically allow it. These are the three consequences, three situations I'm giving you. What would be the outcome of or the fallout of that? No consequences. Will it inure to the benefit of the accused? Will it not inure to the benefit of the accused? Secondly, if these two conflicting reports are coming before the court, the NDPS special court, what would be the role of the judge? Whom to believe and whom not to believe? Should we wait? Everything gets effaced? Or may I say defaced? What will happen? Ultimately in the trial, because you know the criminal jurisprudence,
It has to be beyond reasonable doubt.
if there is a doubt, two contradictory reports are done. What
Goes in benefit of the accused.
What would happen? Which one is to be believed and which one not to be believed? Will he remain in custody for all time to come? Should he? I'm just asking this question. There's nothing. That's why I was just asking, I was really surprised when you intervened, because I'm still a student of law, and I always believe that everyday learning is I think, it's a virtue of a judge or a lawyer. That's why I was just thinking, just
But so to the best of
what
my
to do in
understanding-
this case, what do you think there should be the proper way of doing it?
Not to the
Should we
best
wait?
of my understanding, Lords, there are all these acts and all these statutes, they are divided into different categories. One is a general statute, one is a special statute, then comes the constitution, and on top of it, Lords, is the human rights and the natural rights.
No,
So
no, a bit lower pedestal.
on a bit lower pedestal. Now, what happens? Lords,
Constitution is the paramount, it's the supreme. The only one law in the country is the
No, Lords,
constitution.
if the constitution
Every
violates the
law,
natural right,
every law is subservient to a constitution.
if the constitution violates the natural right, then the constitution has to give way to the natural right.
No,
and the
no,
human right.
Because the natural right flows from the constitution.
If the provision of natural right is not there in the constitution,
No,
or if the
then
constitution
you
is
can't-
inconsistent with
then
the
you
natural
can't-
right.
Then you can't enforce it. It all have to come within the framework of the constitution.
No, that is what I said.
Either we have expanded the horizon of right to life to that extent, the natural life, natural right, human right, everything we have considered.
No,
But
no, what
but
happens?
it all has to be under the constitution.
No, has to be.
So that's a constitution.
What I
of the
say is,
paramount.
if there is a provision in there are general provisions in the general laws. Now, the general law always has to give space to the special statutes. In the same way, if the special statute is inconsistent with the constitution, the special statute goes.
Now,
It has to give way to the constitution.
correct.
In the same fashion, Lords, all these guidelines that are stated here in
So-
DK Basu.
so that's why I say the constitution is a crest of a serpentine, nothing more than.
But all these guidelines that has been given in DK Basu, this has been subsequently put in the CRPC as well.
Correct.
So most of the guidelines they find place there in the CRPC. So at best, it is a statutory violation. It is not a constitutional violation.
Then if there is a statutory violation, then what?
And then bail is not the natural consequence there.
Now, question is that established procedure of law, which is there in Article 21, how it is to be interpreted? Look at the Article 21.
Let me put it in a worst case scenario.
No.
For example,
Okay,
Article 22.
First, let us see Article 21. First, let us see.
A person cannot be deprived of his right in
Yes.
without due process of it.
It says, no person shall be deprived of his life or a personal liberty. This is the case of a personal liberty. Except according to procedure
Established by law.
established by law. What does it mean? Means you can't undermine a personal liberty of a person unless you follow the established procedure of law. If it is not, then is it not an infringing the Article 21, the personal liberty of a person? Is it not? Because the only exception is according to procedure established by law. And now there are two ways of establishing a law. One is by way of a legislation and another by way of the judicial pronouncement, which in English courts is called a common law. It's a common law doctrine. So it has, the flavor of a statute, even under the common law doctrine. You can't deviate therefrom. So in that event, if something has been provided, then what? Is it in accordance with the established procedure of law? And that was really playing in my mind at that point of time when we dictated it.
No, herein we are not dealing with the fact whether the trial would get vitiated or not.
No, it is not.
We
The
are
only
only
thing is there are two
talking about-
aspects. Trial while in custody and the trial while on bail. Trial would remain. It will continue. It will not affect the trial in that sense. I do not know. What would be the outcome? I do not know. But if it is not in accordance with the established procedure of law, then in that event, why the personal liberty should be taken away at this stage? That is what my feeling about the as a student of law. I still
Lord,
consider myself.
There is a provision in the Constitution, Article 22, we are all aware about, Article 22.
What it says.
Section 2, which is
What it
also in Section 57 of the CRPC, which says that the accused has to be produced before the magistrate within
Correct.
24 hours.
Correct.
Let's assume there is a violation there.
Correct.
The accused is not produced before the magistrate within 24 hours.
Correct.
will the natural consequence thereof will be bail.
What? No, that is not, because here lies a fallacy in this. Please come to Article 22, what it says. Every person who is arrested and detained in custody. So the first thing is the detention must be in accordance with law. The custody must be in accordance with the established procedure of law. Shall be produced before the nearest magistrate within a 24 hours of such arrest, excluding the time necessary for travel from the place of arrest to the court of a magistrate, and no such person can be visualized language. No such person shall be detained in custody beyond the set period without the authority of the magistrate. What does it mean? That if it is not produced within 24 hours, then the Constitution says no, his detention is wrong.
Illegal.
But such a detention can be ratified if the magistrate passes an order.
My lordship.
So the Constitution itself given a safeguard that what is to be done. It so happened many a time, I tell you. Many a time it so happened that because of the exigencies, because of certain things,
Is not produced
which
within
is
24.
beyond the control of the officers. That's why the legislature has taken care of that. That if you produce magistrates, definitely it can say, how can you detain beyond the 24 hours? But sometimes the magistrate says, considering the gravity of an offense and being satisfied with the explanation given by an arresting officer, yes, definitely, no difficulty. You can detain.
So even if the arrest is illegal, bail is not the consequence
Oh,
there.
that is what the statute has provided here, that there is a complete silence. I'm again saying, complete silence. What is that? Complete silence. You are thinking that these are the procedure. And if I'm again saying, under a special statute, if it says that he may be produced within 48 hours, say within 72 hours, expanding the time from 24 hours to 72 hours. No difficulty. It is what, again, I'm saying in accordance with the law. Here, absolutely there is a silence. I do not think so, sir, that anything, what you want to, sir, may I use, pardon my impartiality. Is a most conservative way of looking at it.
But my understanding of the thing is not that
So
if there
show
is
me
arrest,
any
then
direct
illegal.
judgment on this, and it says nothing, it gets cured. I'm ready to accept that.
Lord, if I
Though
can
I have not said anywhere, I was reading this dictation, which I have. I have not said anything about it, but still for academic.
Lord,
purpose.
my understanding of the
And today is a day when I think nobody would. Anyhow,
we have enough time today.
yes.
If I can have my lordship on the second judgment that is there, that is Odisha judgment,
Yes.
which was delivered by his lordship, Honorable R.N. Mishra, who later on retired as a Supreme Court judge and Chief Justice in 1990. If I can have my lordship for a moment on para 7 thereof. And this is my understanding of the jurisprudence. It says, what is the consequence of the failure to comply with the requirement of section 57 of the code? Mr. Patnaik for the petitioner has relied upon a number of cases to show that the detention becomes illegal. I have the least doubt in my mind about the correctness of such a proposition. If the petitioner has come before the court challenging his detention without compliance of section 57 of the code, he should have certainly been set at liberty. But as it transpires, he has been already produced before the magistrate and police custody has come to terminate and judicial custody has replaced it. What was illegal detention beyond 24 hours of arrest has now become legalized, and the present detention cannot be attacked on the footing of the
Because of
detention.
the language of section 20, Article 22.
Article 22.
So that means is the
But the
understanding.
first line goes against you.
It does. No, I'm on no side.
No. I'm saying your perception is something different. It was merely a production. Please
The moment the police custody gets converted into a judicial custody, the previous acts get ratified.
that is not in all senses. Not in all senses. It does not provide that how they have to follow the procedures. If the procedure is not followed, then what would happen? It says apprehension, you cannot keep him beyond 24 hours. You'll have to produce it before the magistrate. Once you are produced before the magistrate, if it appears that beyond 24 hours you have produced it, then the magistrate can ratify. That power is reserved upon the magistrate. That it can. But otherwise, if the procedure has not been followed, then what? It was only, procedure was followed. Only thing was that he was produced beyond 24 hours. And the Article 22 takes care of it. That's why the first line has to be read in this. When it says, when the consequence of failure to comply with the requirements of section 57 of the code. That is, what is the consequences it says? What 57 says? What it says?
Within 24 hours.
Correct. That's the only thing.
That is replica of 22.
Please. That is what I'm saying. Mr. Patnaik or the petitioner has relied upon a number of cases to show that the detention becomes illegal. I have least doubt in my mind about the correctness of such a proposition. What does it mean? That those propositions are absolutely correct.
Yes.
Because if it is not followed, the procedure is not followed. What it says is the procedure is not followed, then it says, if the petitioner has come before the court challenging his detention without compliance of 57, he should have certainly been set at a liberty. Now, question is, again, I am saying, if the petitioner comes and says that I have been detained illegally, I have not been produced within 24 hours, the judgment says that he should be set at liberty immediately. Since he chose not to.
He did not utilize that window.
Then the court says, but it transpires that he has already been produced before the magistrate, and then terminate judicial custody has been replaced. Question is again a default claim. Take an example of a default claim. You know the recent judgments on this.
A window is there that has to be timely utilized.
If, say, the 90 days or a 120 days under the special statute, whatever, if the charge sheet is not done, then if he applies for a bail.
Indefeasible right. It is an indefeasible right. It will be given bail. But if it does not apply within that period.
I'm coming. You talked about those words. That's why I'm taken it back. Indivisible right. No. It's not that indivisible right. Only thing is that if you apply at 91 days, even if the charge sheet is filed on 92nd day, to that extent, he has an indivisible right.
But once the window gets closed.
But if he did not apply on 91 and applied on 93rd day, and on 92nd day, the charge sheet is filed, then there is
then the window is closed.
Then there is a debatable question. It's still pending before the Supreme Court that what is he meant by a indivisible right. As of now, the judgment is, it says no. There is no difficulty. You can't seek a default. Right from Sanjay Das,
the window gets closed.
Then Navjot Singh Sidhu. There are many
Ravindran.
There are many judgments which has come. So this is how the scenario really comes. This is the case.
To my understanding, Milords, a similar window gets opened when there is an illegal arrest.
He has come. I don't think so. Any other judgment?
Milord,
No.
No.
In fact, this is something that was relied upon later on, Milords. The situation got changed in the Supreme Court itself. But in a recent judgment of Senthil Balaji, Milords, again, the Supreme Court has gone square back to where it started from the Orissa judgment. It says that no, once that window is closed, thereafter illegal arrest.
Milord, if I may submit just one judgment. Milord Satinder Kumar Antal. Milord, to my limited understanding, Milord, this judgment of the Supreme Court, Milord, shares its spirit with the D.K. Basu judgment.
My brother has more experience in this branch of law than me. He has referred section 60 capital A of the
Milord, certainly which has been set out in Satinder Kumar Ankel's judgment.
He has said, and it says that no arrest shall be made except in accordance with the provision of this code or any other law for the time being in court providing for arrest.
Lord, kindly seize this judgment.
What has to be done? 68 came when amendments 2009. It is up to 41B.
Because 60A has to be read in
2010.
consonance with section
2010.
51 of NDPS Act. Because 51 of NDPS Act says that CRPC would be applicable only
Only
when
when
it is inconsistent with
inconsistency.
only
No,
when
I
it is
know. I have
inconsistent with the
quoted-
NDPS Act.
I have quoted that in my dictation yesterday itself. I have quoted it. Section 51, I have said, this is section 51 of the said act engulfed within itself the provision of the code of criminal procedure to apply in relation to an offence committed under the said act, provided such provisions contained in the code is not inconsistent with the provision of the statute.
And because NDPS
This
is
is what
provided
I
for its
want
own
to-
procedure of arrest.
No, it does not. It does not.
60A, my lords, it cannot be looked into in the way, my lords, that it has been written there.
Anyhow, yes, which paragraph?
My lord, page 13, para 24.
Para?
24, my lord. Now, to my
24.
24, my lord. Now, to my understanding, this judgment shares its spirit with the judgment of the DK Basu. Now, kindly see para 24. Page 13, my lord.
Yes.
It sets out, my lord, that 41B is a mandate.
I think wonderfully worded judgment which has been quoted in this.
My lord.
Applied, that is Arnes
Kumar, Anish Kumar.
of 2014 volume 8 SSC phase 2. Wonderfully, and it gives all answer to what your arguments
Arnesh
are.
Kumar is on 41A, my lord.
No, it's 41B also. It takes care of. It's not that we have.
My lord.
Both are considered. Maybe on 41A, more discussions have been made,
My lord.
but it considers both the provisions. May I read this particular, the sentence where it takes care of 41B as well?
My lord. Para 24, my lord.
No, I'm just,
One-
I'm just giving that particular provision. Yes, 24.
Lord.
Section 41A deals with the procedure for appearance before the police officer, who is required to issue notice to a person against whom the reasonable complaint has been made or credible information has been received, or a reasonable suspicion exists that he has committed an cognizance offence, and arrest is not required under section 41A1. Section 41B deals with the procedure of arrest along with the mandatory duty on the part of the officer.
My lord.
And then it says that what are the mandatory duties which is required, not quoting that 41B in that sense, but the sense can be gathered there.
But my lord also comes to para 30 of this judgment. 30.
And wonderfully examples have been given. Wonderful examples.
30 is at page 16, my lord.
And this goes against this particular judgment of Odisha. It goes against the spirit of Odisha. Does not say so. No, the judgment is absolutely correct. Anyhow, thank you for detaining us on an academic side. Yes. One. Though the order was dictated in the open court on Friday, we did the but on an intervention of a respectful member of the bar, who is more keen on the development of the law and the concerns in relation to the various nuances of law. We postponed the transcription of the order and invited the counsels appearing for the respective parties, including Mr. Mishra, who intervened in the matter for the cause of law to address us. To address us on such issues. After hearing the counsel, we do not think that after hearing the counsel, including Mr. Mishra, who rendered pro bono services as an officer of the court, we dispose of the application in the following.
I'm deeply.
Yes, yes, continue. You propose will continue. No. Go ahead. We do not do. I'm ready. We are ready. And we are very eager.
Personal accidents,
Call.
আমরা তো ছিলাম রেডি, এখন কি হবে কি হবে না দ্যাট ইজ কনফিউশন। পড়াটাকে ঠিক হবে, ওখানে কিছু করছে না, পড়াটাকে ঠিক হবে।
Please don't shout.
As per the direction of the Honorable Court, present before your lordship.
Why Kaji?
Muslim law, Shariati law has been maintained and marriage has been solemnized in
Just we wanted,
Sharia
the
law.
earlier bench wanted to know from the registrar, the Kaji, whether there is any impediment, why
secretary of our association, yeah, just asked me to inform your lordship, maintain that resolution of the principalship.
What is the resolution? I am unable to understand.
So far, I received a call from him, the resolution was taken by the principalship for not to attend.
So what does it mean? How it is to be followed and what is to be understood?
I have been asked to inform your lordship.
What cannot write, your lawyer doesn't have been that.
Just one hour from
Let's go to the next.
Lordship, small intelligence lordship. I'm led by Mr. Arjun Chaudhary. He is appearing on virtual mode for item number 266. Kindly appear,
Just call.
Lordship.
260.
Let's go to the next.
Lordship, we are for the CBI.
Which for the petitioner 16, Shubhasis Misra. Mr. Misra.
My lord, kindly appreciate, we are being compelled to detain the CD. And it is already a week we have detained the CD.
He's opposing, then you'll have to do them.
But there is a resolution, my lord, if I.
Resolution, I think he's also member or not a member.
He's a member, my lord.
So if he can appear, then why can't you?
But he's for the prosecution, my lord, state, my
So
lord. That
what?
is why they have the
They
urgency,
are-
my lord.
They stand on a different footing than you.
My lord, on Monday, my lord. I'm ready, my lord, but
Convince him.
Monday, my lord.
Lordship,
That is not ours.
Lordship. My lord, okay. My lord, if it can be accommodated on Wednesday, because the CD will go back, we cannot keep it.
Wednesday we have kept for that civil matter.
Then my lord, Tuesday,
Monday, any difficulty?
my lord, the CD will go back, by some chance it doesn't come back on Monday, we will be in a awkward position. So,
What did you detain it? You can't detain it for a day.
my lord, we detained it, but now with the 2 days holiday, nobody will be there to guard the CD in my office. And if it is lost, my lord, I will be questionable and the officer will lose his job.
Tuesday, then you are asking for an update.
Tuesday, my lord, kindly puts in the top of the list.
Next.
18, my lord.
18 also, my lord, same, my lord.
My lord, virtually the trial is over. Only the IO remains.
So
But let it be hard on, my lord, Tuesday.
both
I want to argue, my lord.
next.
With your leave, my lord.
No, no.
158. Who's for the other side?
My lord, 166, my lord, I am for the petitioner.
166.
My lord.
He says 166.
Oh, sorry, my lord, 266, my lord, I'm sorry, my lord.
My lord, I am for 225.
Yes, 225.
My lord, it's a appeal matter, my lord. It's a bail in connection with appeal, my lord.
Yes.
If it pleases me, pleases your lordship, my lord. I am the appellant, my lord. I am charged under section 302.
My lord, one thing I have to inform him, he is not aware of, actually you are the member of the bar and the bar has taken a decision not to attend today. So whether still violating that we'll be doing the case, then we'll get prepared.
My lord, then fix it on Monday, my lord, at the top of the list. Because, my lord, in the chronological order, if it remains, my lord, I will be always put numbered as to after 200.
No, don't worry about it. We will consider it. The bail in connection with the appeal. That
My
we'll
lord.
consider. Let us see.
Because,
We'll
my lord,
pick
I
one
am
day.
filed this petition 4 months earlier, my lord.
Yes, let us see. We will take up this application. Don't worry.
My lord,
We will just make a reverse situation. Now we have taken a bail, anticipatory bail, then we will reverse. That first the bail in connection with appeal, then we'll go in that direction. Don't worry, everybody will get a chance.
My lord, my lord. My lord. Then not today, my lord.
Yes.
Lordship, I'm led by Mr. Arjun Chaudhary. He is appearing on virtual mode, Lordship.
Yes.
My lord, I am for the petitioner in item number 266.
Yes.
But this
Yes.
is not mandamus application, my lord.
What is this mandamus appeal?
My lord, the mandamus appeal, my lord, arises out of an impugned order passed by the Honorable Single Judge in the writ petition. My lord,
Yes.
the writ petition was primarily filed, my lord, for police inaction. My lord, I was the de facto complainant as well as the victim in a criminal case under section 307 and 326. My lord, I was badly injured, my lord. I had received serious injury, and my lord, this FIR was lodged against the accused persons. My lord, the police was not taking any action. My lord, aggrieved by that, I filed the writ petition. Now, my lord, what happened during the writ petition in the first courts, the Honorable Single Judge, my lord, passed an order directing the investigating officer to produce the accused person before the Honorable Single Judge. And my lord, thereafter, by virtue of that order, my lord, on the second day, the accused person was brought before the Honorable Single Judge. The accused person was examined in court. And my lord, the accused person made certain allegations in court before the Honorable Judge that I was involved in a case under section 376 with a lady, and in view of that, my lord, he has assaulted me, and that is why, my lord, I have received the injury. This was the statement. And seeing this allegation, my lord, the victim lady, who has no connection with the instant case, my lord, she was added as a party. I was called personally in court, and I was directed to marry the victim lady, my lord, in connection to a different criminal case. I was directed to marry the victim lady. When I refused to marry the victim lady, my lord, in court, my lord, I was directed to undergo a DNA test. My lord, aggrieved by that, my lord, this present mandamus appeal along with the stay application has been preferred before your lordship.
Who is for the state? Who is appearing?
Mr. Pritam Dash probably is appearing for the state. My lord, service is complete. My learned junior is holding the affidavit of service, my lord.
Give him a notice that this matter would be taken up on Tuesday.
My lord, my lord. I'm grateful, my lord.
Tuesday.
Grateful, my lord. Grateful.
File tag to Patidev. देखिए oh. Yes, call the next.
Milords, I'm sorry, Milords. May I mention item 229, Milords?
What?
Milords, this is a second appeal, Milords, coming up for the first time.
Second appeal for admission.
Please, Milords.
Yes, can you argue?
Yes, Milords, if your lordship
Argue?
permits, Milords.
Yes,
So,
let us complete the call, then we'll take up to 29. In the
I'm
meantime,
grateful, Milords.
bring out the file. Because the presence of other side is not required.
Please, Milords.
Yes.
Please, Milords.
Who are you, the plaintiff or the defendant in a suit?
Milords, I was the defendant in the suit. This was a suit filed by my aunt.
First thing is defendant in a suit and a suit filed by your client. How can you file a suit?
No, Milords. I'm sorry, Milords. I was the defendant in the suit. The suit was filed by the plaintiff, who's here, respondent, Milords.
Correct. And it's a judgment of affirmance or reversal?
Milords, it's a reversal, Milords. The trial court held in my favor, dismissed the suit. The district judge reversed it and decreed the suit.
What is the nature of the suit?
Milords, this is a suit for cancellation of gift deed, which is registered. And the allegation, Milords, the plaintiff raised is
at the
that
behest of the donor or the heirs of the donor?
by the donor, Milords.
By the donor herself?
Yes, Milords.
Yes, what is the point? Substantial question of law?
Please, Milords. Milords, initially when the suit was filed before the trial court, the plaintiff took a position that the cancellation deed was vitiated by fraud, misrepresentation, and
Yes.
sheet simpliciter asked for a declaration for cancellation. When the matter was ready for final arguments, Milords, on the eve, they filed an application for a subsequent relief, which is for possession as well. Although, Milords, all along, the claim of the plaintiff was that she was in possession. But subsequently, before the final arguments, after evidence was complete, she reversed the position, filed an application for adding a prayer of possession, Milords. This is by virtue of Section 34 of Specific Relief Act. Milord knows if there is a consequent relief which has to be sought for, if that is not
Where
sought,
is
the
a
suit
where is
filed.
a plaint? Where is
Yes,
a plaint?
My lords, the plaint, my lords, I'll just give you in a moment, my lords. This starts at, my lords, page 69.
Are you ready with all the latest judgment on section 34?
My lords, I don't
Are
have
you
the,
taking a risk of doing that?
my lords, I will be, my lords, candid with your lordship. I don't have the judgments, my lords, but this.
Now show us the plaint.
Yes, my lords. My lords, the plaint, my lords, starts at page 69.
Correct. Show
And
us
my
the
lords-
prayer portion.
Yes, my lords. The prayer, my lords, is at page 73.
So mandatory and permanent injunction has been sought.
Yes, my lords. Simpliciter.
Yes,
my lords. My lords, I have filed a supplementary affidavit, my lords, where there is an application, my lords. My lords will see the supplementary affidavit.
So the question is, your only point is that they subsequently asked for a relief in the form of a position.
Please, my lords, that application was rejected.
So rejected. So that means that the consequential prayer required under section 34 proviso has
my
not
lords.
been complied with. So the suit must fail.
Please, my lords.
That's your ground?
That's one, and there's
That's
another
one.
ground.
Yes. Then what is the second?
Yes, my lords. My lords, I'll straight away, my lords, if I can kindly draw your attention to page 24, my lords, that's the relevant portion of the impugned judgment.
Yes. What is the appellate court or a trial court?
Appellate court, my lords, the judgment which is impugned before your lordships. Page
Yes.
24. So, my lords, what had happened is the plaintiff herself had given an evidence. My lords, if I may read the first paragraph.
Yes.
However, the PW1 in her cross-examination admits the defense suggestion that the ADSR inquired her why she was present before the registering authority, and the PW3 in his cross-examination states that the ADSR inquired her about the nature of deed. So, my lords, in the evidence, it has clearly come that the plaintiff knew about the nature and why the gift deed was being registered.
Yes.
My lords, then my lords will kindly see the next paragraph. The learned trial court came to the finding that the defendant did not practice fraud on the plaintiff in obtaining the deed of gift on the basis of the evidence of PW1 and the PW3 that she admitted execution of the deed, and the ADSR inquired her about the nature of the deed and the purpose of her visiting the registry office.
Then,
my lords, this is the erroneous position, the next paragraph. No prevalent rule or practice is cited by the learned advocate for the respondent showing that the registering authority reads over and explains contents of the deed to the executor and proceeds for registration only after being satisfied that she has understood the nature and consequence of the transaction. Execution is not only a physical act but a mental act. So mere inquiry by the registering authority about nature of the deed cannot be due compliance of above principles of law laid down by the Honorable Supreme Court and the Honorable High Court in respect of
now
deeds.
what is the foundation of treating this document to be void, illegal? What was the ground taken? Fraud, undue influence, coercion, misrepresentation, anything of that kind has been taken?
Yes, my lords. All of that, in fact, was taken in the plaint, my lords. And I'll straight away, my lords, draw your attention.
How the appellate court has arrived at the finding? What about the undue influence, coercion? What is that?
My lords, so in my respectful submission, my lords, the appellate court does not deal with any of those allegations.
Yes.
What the appellate court does is reverses the burden of proof and says that I, as the defendant, was under a burden to show that the plaintiff has understood. And despite, my lords, there being clear evidence of the plaintiff herself, where she admits in cross-examination that she understood the nature of deed, the appellate court says, no, you have not discharged your burden and therefore I will cancel the deed.
What is the law? Because I have seen from the finding that the plaintiff in her deposition reiterates that she has an elementary education and does not know English.
Please, my lords.
She's not conversant, it should be. She's not controverted on this fact in her cross-examination. The defendant has not adduced any evidence to the contrary. Now, if she is regarded as a illiterate lady, cannot read, write, or cannot put a signature, or can only put a signature, then how the burden of proof lies?
Yes, my lords. Insofar as that is concerned, my lords, Number one, the factual position is that she is semi-literate. She is not illiterate.
No, she
Point number
said
one.
that does not know on the English language, whether the document contains any kind of a certification.
Milord, in a plaint itself, she says that she is semi-literate.
No, she wanted, one thing is that she knows the nature of the document.
Please,
Whether
my lords.
she intended to do it is a vexed question. Secondly, if her intention is also manifest, whether that intention was tainted by any kind of a fraud, coercion, misrepresentation, or of any kind.
Milords, the allegation in the plaint is that she was misrepresented and fraudulently her signatures were obtained on this deed. She was told that this is a conversion deed.
So if that being the position, then the onus lies on you to prove it that it has been done.
Please, Milords. So, Milords, insofar as Milords, what my respectful submission before
Did you bring the attesting witness to be
Milords,
to be a part of?
PW3 is the attesting witness who was brought by the plaintiff herself. And the attesting witness, Milords, deposes before the trial court that she's understood the nature and contents.
No, nothing. Only thing is that what you wanted to execute, she said the deed of gift, but it was, may I know is a foundation whereof is of a coercion or something of that kind that will come.
Milords, there's no
Is a
allegation
conditional
of
gift. It's a conditional gift or an unconditional gift.
Unconditional gift, Milords, and there is no allegation of coercion, Milords.
Then in order to prove it, then something has to be done. Then what is the third point?
So, Milords, the third point is, Milords, there were about 5 issues which the trial court had framed on the factual aspects, and all of that were answered. However, Milords, the appellate court, in my respectful submission, does not get into any other issues and brings in a new issue to say that you have not discharged the burden of proof without considering all other issues. So, Milords, that, in my respectful submission,
if the trial court has wrongly applied the onus, why not the appellate court can say that it was an onus of the defendant to prove?
No, Milords, I bow down, Milords, to what's
so where is the
fallen from your
difficulty?
lordship.
Where is the
Milords,
difficulty?
I bow down, Milords. All I am saying is, Milords, on all other aspects, there is absolutely no finding of the appellate court, Milords.
No difficulty. It is not required. If the onus is wrongly shifted, then in that event, what more?
Milords, but the prima facie burden, Milords, I have discharged, and Milords, there is also settled position of law, Milords, that in case where both parties adduce evidence, in that case, Milords, the onus of proof actually goes into grey. Then you cannot, as a trial judge, Milords, fix
it is in
onus
case
on
of it applies in case of a Pardanasi or an illiterate lady. I am asking in that. You are talking settled proposition of law. We are conscious that when both the parties are aware and they have gone and participated in trial, then the question of onus takes a back seat. It becomes mere academic. The expression is mere academic, nothing more than that. But in case of a Pardanasi or the illiterate lady, what will happen?
Milords, the point
it is the same law which will apply.
I bow down to what's fallen from your lordship, Milords, but the 2 points here is, Milords, one, the plaint itself says she is not illiterate, she is semi-literate. So the point is...
No, she says that I have read up to elementary level. She has not said I am a semi-literate. Elementary level.
Milords,
what does it mean? Only that shows that I am very much accustomed or familiar with the alphabets and the numerical numbers.
Milords, that
what is the elementary studies?
Milords, that itself shows that she is not an illiterate.
No, what do you say? Oh, what are you say? I can read and write. I can simply write my name. That is mean that I am a literate one.
No, Milords.
What are you talking about?
No, Milords, I'm sorry, Milords. I'm not on that. I'm not on that point, Milords. The point
Oh, definitely not. Definitely not.
Milords, in that case, Milords, this goes back to the section 34 argument, Milords. That has
I
to
think
be
that goes against you in view of the latest pronouncement of the Supreme Court.
Milords, then Milords will give me some time. I'll check that.
That's why I asked, are you ready? You said, yes, absolutely.
No, Milords, I was candid enough to, Milords, say, Milords, I will check.
Read the judgment of the latest judgment of the Supreme Court in Akamma.
I will come back.
AKAMMA, Akamma, of Justice Aniruddha Bose.
Please, Milords, I'm grateful. Milords.
Read the latest judgment.
Please, my lords.
And more bad, I think the bad fact than you. And section 34 was said not to have no application.
Milords, although, Milords, I must point out, Milords, in this case, the appellate court does not even consider the applicability.
We can, if the ultimate decision of the court appears to be correct, then the higher court can substitute its finding. No difficulty.
That very well,
Why?
Milords, but
So where is the difficulty? If
but
the
my-
ultimate decision is found to be correct, section 34 in your case does not apply. Read the judgment of Akama.
I'm grateful, Milords. I'll come back.
That was more bad facts than your case.
Milords, I will come back after reading that, Milords.
I know it, but it can be, there is no difficulty in this regard, but there are certain procedures which are to be followed under these circumstances. What? And if after all it affects the transfer or it affects the property itself. And section 123 of the Transfer of Property Act defines that particular gift, how it should operate. And thereafter, one has to understand if these deeds are impugned on the ground, like from section 15 onwards of the Contract Act, there's a fraud, coercion, undue influence, then the execution is not denied. She has not said that these are not my signature. Everything has been given. But if my decision to execute a document is tainted with a kind of a fraud or some misrepresentation, which led me to believe certain things to exist, and those things never exist, then can I not come? Undue influence. Somebody influenced me to execute, but it was not my free will. I never intended, but it was under an influence. Sometimes the fiduciary relationship creates a problem. So these are all the basic principles of getting away those properties. And the respondent have no right of audience unless the admission is done. Yes. So we don't look at the respondent. Come, read Akama.
Please, my lords. I'm grateful.
This, my lord, this matter. We also on the last occasion we have heard that matter. We also have done some homework in our house for the last 2 days. Regarding the one clarification only required, my lord. Regarding this is just for academic discussion, my lord.
Yes.
My lord, that's right. Thing is that regarding the memo of arrest, my lord, is it a proof of arrest or just an intimation to the arrest?
No, it's a procedure followed for arrest.
Or as per the column 10.
It's a procedure, which are the procedure. There are two aspects, I tell you everything.
Madam, it's a
Because
special laws. So
no,
first search is the daily
no.
laws.
Then first is the search.
Yes, search is
Second is a seizure,
followed by
and third is the arrest. Now the question is, if there is a provisions relating to an arrest, and if there is a format which is given, and non-compliance will really create some kind of a right into a person, then why not? Maybe a procedure. Why the Article 21? That's why I said the procedure except in accordance with the procedure established by law. What is the meaning of the word procedure?
There's a reportable judgment of the Supreme Court also. This is a Sentinel Balaji.
I know.
These are
I know.
These acts are injurious.
These are, I understand. I think a PMLA case
Yes, ma'am.
is there, and it was
For
cited.
the larger, for Chief Justice for the larger branch.
Let us see for the time being.
I made a little, regarding 41B, Lordship Stanley was saying. Because the latest, what we found is a research work.
There was a vacation after Saraswati Puja and we have.
No, always, definitely. We'll take care of this.
Yes, from my side. But that for the last 2 days we have gone through it.
That is how the law develops. If there is no research, then it does not. Read, sir, judgment of comma and then argue 34.
Please, my lords.
That is a more worst fact than you. In that case, there was an earlier suit. In an earlier suit, it was held by the court that the plaintiff is not in possession of the property. The subsequent suit was filed without any relief in the form of a recovery opposition. Only the mandatory injunction or permanent injunction was there. The Supreme Court has said it is not fatal under section 34. If that case is not fatal, then your case certainly will not be fatal.
My lords, I'll read that and my lords come back, my lords. I'm grateful, my lords. I'm deeply grateful.
Yes. It a chamber party.